Mr.
President.
The Leader of the Opposition.
Mr. President, I lead for the opposition in debate on the Crimes Amendment Intimate Images Bill 2017. The opposition does not oppose the bill. As the Parliamentary Secretary pointed out, the object of the bill is to amend the Crimes Act to create new offences in relation to the non-consensual sharing of intimate images, the non-consensual distribution of intimate images, also commonly called revenge porn and in some contexts called image-based sexual abuse, has increased substantially in line with technological developments. Images can be distributed frequently and easily given the availability of online platforms. There is broad agreement about the significant harm that can result for the victims of this behaviour. It is all too widespread, particularly in generations younger than myself. In a submission on the government's discussion paper, Dr Nicola Henry, Dr Anastasia Howell and Dr Asher Flynn referred to their Australian survey on online abuse and harassment, which had almost 3,000 adult Australian respondents. The survey found that 1 in 10 Australians had a nude or semi-nude image of them distributed online or sent to others without their permission. This type of behaviour is often associated with domestic violence. The submission from the Eastern Suburbs Domestic Violence Network specifically notes an increase in the use of technology to perpetrate domestic violence. There is a wide range of motivations and intentions involved, however, and as the government has noted previously, what constitutes an intimate image can vary according to community standards. There is currently no clear dedicated criminal offence to deal simply with the non-consensual sharing of intimate images. There are several provisions that in some circumstances cover some of those situations. In the case of 578C of the Crimes Act, publishing indecent articles, a person needs to do some conceptual damage to make it fit these circumstances. If the image was created consensually, it seems on to regarded as indecent and rely upon its nature to found a prosecution and only regarded as indecent when distributed. The Commonwealth Senate Legal and Constitutional Committee, in a report released on 25 February 2016, recommended the introduction by states of a criminal offence directed at this behaviour. The Legislative Council Standing Committee on Law and Justice released a report in March 2016 entitled Remedies for the Serious Invasion of Privacy in New South Wales. The report was restricted to civil remedies but did suggest that the state government consider the Senate committee recommendations. The former Attorney-General eventually released a discussion paper in September of last year. Public submissions closed in October 2016. The opposition thought the government was unduly delaying taking action on the issue, and the Shadow Attorney and the other place placed a question on notice on 9 May asking what legislative action was proposed. Whether that was the catalyst or not, the Attorney-General announced the new laws on 21 May in a Sunday newspaper. I will say one other thing about the way in which the committee came about, and I also commend the committee for its work and for producing unanimous recommendations. But the inquiry did take a bit of pushing and shoving to get off the ground. I remember it was my colleague, the Honourable Mick Veitch, who came to me most concerned about the phenomenon of what was called revenge porn. He had read some articles in the newspaper, and he came to me and said, "This doesn't seem right, we should do something about it." And he placed a motion on the notice paper. And it languished there for quite some time, although it was the subject of discussion between various members and parties in this place, which I will not go into in detail. But it did take, as I said, some insistence on the part of the opposition to create a situation where eventually this House unanimously adopted the terms of reference or the referral. And I just wanted to pay a tribute to the Honourable Mick Veitch's his concern about the issue and his foresight in putting a motion forward to deal with the issue, but also all members for eventually embracing the need for the inquiry, because it does transcend parties, it does transcend geography, and I think even the most casual observer would recognise that there was a definite problem that does need addressing. In particular, when the Honourable Mick Veitch came to me, we did some research, and of course there were 2 cases only in Australia that we could find that dealt with the phenomenon. They dealt with it in very different ways, and neither was terribly satisfactory. And Whether the criminal law is really the only or the best way in which to address the phenomenon remains to be seen. The opposition, of course, in the other place, did propose a bill that does or did seek to implement the recommendations of the committee's report in a civil way, particularly the civil takedown orders to be reposed in the Office of the Privacy Commissioner, and that bill has also been given notice of in this place by myself. And I do look forward to the same cross-party consensus for the need for action overwhelming us in this chamber as it is in relation to this bill now before the House. It seems to the opposition that the most problematic area concerning the sharing of intimate images is the practice by children and young persons of sexting, the consensual creation and sharing of sexually explicit images or messages. The submission on the discussion paper by the Advocate for Children and Young People quotes research to show that consensual sexting is commonplace among young people and children. The research quoted said that of those aged 13 to 15 years, 38% had sent a sexual picture or video and 62% had received one. Of those aged 16 to 18, 50% had sent one and 70% had received one. And of those aged 19 and older, a quite staggering 59% had sent one and 68% had received one. The black letter law approach to this part of the issue in this debate is to say that because such sexting is consensual, it is not caught by this bill. But it's more complicated than that. If the recipient of a sexting image shows it to someone else without consent, then that certainly is going to be caught by the legislation before this House. Additionally, child abuse material offences continue to apply to consensual sexting. In turn, that might have had implications for sex offenders registration and working with children's chicks, but we understand that the Department of Justice is conducting a review of child sexual assault laws presently, and we assume that that review arose from the recommendations of the Joint Select Committee on Sentencing of Child Sexual Assault Offenders, which was chaired by Troy Grant, and the Shadow Attorney, Mr Lynch, was a member. We understand that sexting will be considered in that review. There is clearly an intersection between this bill and the matters being considered by that review, and we ask several new criminal offences are created by the bill. It's appropriate to note, as recommended by the Bar Association, that these are new offences and not simply amendments of the provisions of existing law, such as Section 91 capital K and Section 91 capital L of the Crimes Act. Section 91 capital P provides that a person who intentionally records an intimate image of another person without that person's consent, or being reckless as to whether the person consented, is guilty of an offence. Section 91Q provides that a person who intentionally distributes an intimate image of another without that person's consent, or being reckless as to consent, is also guilty of an offence. Section 91 capital R criminalises the behaviour of threatening to record or distribute an intimate image. The penalties for all of these offences is 100 penalty units or imprisonment for 3 years, or both. These are indictable offences. The amendment made by this bill to the Criminal Procedure Act also makes these 4 offences Table 2 offences. This is consistent with submissions from the Office of the Director of Public Prosecutions and also the Legal Aid Commission. It means they can be dealt with summarily unless the prosecution or defence objects. The maximum penalty in such cases is 2 years. Making them indictable avoids time limitation problems that might otherwise arise, a point I note that the Privacy Commissioner mentioned in her submission. All of these offences are subject to a proviso that the prosecution of a person under 16 years of age cannot be commenced without the approval of the Director of Public Prosecutions. This reflects the issue of how these laws intersect with the behaviour of children and young people. Once upon a time, this would probably have been a provision that prosecution not occur without the Attorney General's consent. And indeed, that proposal was made in the submission by the Kingsford Legal Centre. As a matter of practicality, those times have probably passed, and in any case, the provisions about the Director of Public Prosecutions is probably a preferable option to having consent resting with the Attorney General, who is, of course, a politician and a member of Cabinet, not only the First Law Officer of the state. As I understand it, successive attorneys have delegated such functions under other legislation to the Director of Public Prosecutions in any event. Section 91 capital S allows a court to order a defendant to take reasonable actions to remove, retract, recover, delete or destroy any intimate image recorded or distributed. It's important to note what this does and what it does not do. It operates only upon conviction, so no pre-conviction takedown order can be made, and we think that is far too late. It's only directed at the defendant, not at any other body or organisation or person. Failure to comply with the order is a criminal offence. The maximum penalty is 50 penalty units or imprisonment for 2 years or both, and that is a summary offence. Comparatively complex definitions are provided in the bill. In the circumstances, that makes sense. Intimate images is defined in a way that is based upon the terms of private parts and engaged in a private act, and they are in turn defined with some precision. I note the attorney in the other place in his reply did deal with the issue of the takedown orders and did say that in the context of a criminal statute which is proposed, the limitation was appropriate, but what that really does is to underscore that whatever the benefits of this legislation, the effective redress for a victim of this behaviour is not some criminal prosecution months or perhaps even some years after the event, but very soon after he or more usually she, becomes aware, and there is an effective redress through the power to take down the images swiftly. And that is what is not provided for in the bill, probably because it cannot be given the nature of the bill, but it is a call to arms to all of us in this chamber to not let that issue rest, because I think what we're all about here is justice for people who are the victims of this terrible behaviour. And effective justice is to make the victimisation the offending end. And as long as the intimate images, the non-consensual intimate images, are at large, the victim continues to be attacked by any offender. So we must return to that, and we should do so swiftly. And as I indicated earlier, that mechanism is before this chamber. The power to remedy that issue is in our hands, and we can do it swiftly if the bill progresses. Intimate image is also defined to mean an image that has been altered to appear to show a person's private parts or a person engaged in a private act in circumstances in which a reasonable person would reasonably expect to be afforded privacy. And that's an important thing, because one of the other victimisations is people's faces being grafted onto other images of other persons and made to look as if they are engaged in that activity, which is completely unacceptable. New section 91 capital O has detailed provisions as to the meaning of consent, and once again that seems to be entirely sensible in this legislation. New section 91 capital T provides a number of exceptions to offences under section 91 capital P and section 91 capital Q. They include if it was done for a genuine medical or scientific purpose, if it was done by a law enforcement officer for a genuine law enforcement purpose, if it was done for the purpose of legal proceedings, and if a reasonable person would have regarded the conduct as acceptable, bearing in mind, Mr. President, a number of factors. It's an interesting provision and seems in relation to the latter part to adopt the reasoning of the submission of the Children's Court President, Judge Peter Johnston, who argued against the use of a community standards component in the defence such as exists in Victoria. He argued that this was too vague a description and it might be difficult for a judicial officer to be sure of its meaning. The notion of reasonableness, as provided in this bill, is one with which judicial officers are quite familiar. That might not be quite so with the term acceptable, which is also in the bill. And I note that the Attorney General in the other place, in his reply speech, actually explicitly acknowledged that the legislation did adopt the submission of the Children's Court President, Judge Peter Johnston. So I think that's important in terms of the way in which this legislation may be applied and construed by the courts into the future. Turning specifically to the submissions on the discussion paper, the Attorney-General in the other place was invited to address two issues in reply. The first related to the proposal by the Director of Public Prosecutions that the penalty for the offences be 5 years maximum imprisonment, consistent with the provisions of Section 13 of the Crimes, Domestic and Personal Violence Act 2007. And that was because it was appropriate that there be an explanation of why 3 years maximum penalty was adopted in this bill rather than the 5 years maximum that the DPP proposed. Now, in reply, the attorney in the other place indicated that consideration was given to like provisions in Victoria, where the punishment was 2 years, and in South Australia, where the punishment was 2 years or 4 years if the victim was under 17, and that it was thought here that the offences or the provisions of Section 13 of the Crimes, Domestic and Personal Violence Act was of a higher level of culpability than the offending caught by this Act, such that the lower penalty of 3 years rather than 5 years was appropriate. Now, I understand the reasoning, but we are not necessarily convinced that that is right, and we think that should be reviewed in a reasonable period of time. The second issue about which the Attorney-General was asked to respond to came from the submission by the Legal Aid Commission of New South Wales and other submissions that the prescribed orders for apprehended violence orders be reviewed to include a provision that prohibits the threatened or actual distribution of intimate images without consent. And my understanding is that the Attorney-General indicated that that would be reviewed. If that can be confirmed, that would be good. Otherwise, we just we'll pursue it in another way. The part of the bill that is troubling, as we indicated, was the inadequate regime for offending images to be removed. 91 capital S limits rectification to orders only after conviction, and of course there are the very significant time lapses involving criminal prosecutions mean that while this is an important measure, it will not give justice to victims, and we will revisit that ourselves if the government does not. I note the support for the approach recommended by the Law and Justice Committee and embraced by the opposition in the submission from the Kingsford Legal Centre and the Law Society for New South Wales are not a radical bunch of leftists. This is simply a more, we think, expeditious, simple and effective way of dealing with these sorts of images going up and be distributed. And a civil regime of the kind envisaged in the opposition's bill, we think, would work nicely or neatly in tandem with this criminal statute. And with those observations, as I indicated at the outset, we will not be opposing this legislation and hope that it has a swift passage.